Hello everybody, welcome to ixamBee. This is Amrita, and in this video today I am going to discuss with you an important set of questions from the series that we have started for 100 most important questions for Sebi Grade A Legal Officer Examination. Friends, we have started with this series which will be including total of 5 parts. I have covered part 1 and in this video I am going to cover part 2 of the questions. But before that, don't forget to subscribe to our YouTube channel. Write to us at hello@ixamBee.com. Call on the number that is visible, or you can visit www.ixamBee.com for further details relating to government exams preparation as we make it easy over here. Starting with the discussion relating to the 100 most important questions. पार्ट 1 के जो सीरीज में हम लोगों ने पार्ट 1 में जो डिस्कस किए थे टॉपिक्स, वी हैव कवर्ड कॉन्स्टिट्यूशनल लॉ, एडमिनिस्ट्रेटिव लॉ, ज्यूरिस्प्रूडेंस, इंटरप्रिटेशन. आज के सेट में हम लोग डिस्कस करने वाले हैं मिक्सचर ऑफ क्वेश्चंस फ्रॉम द टॉपिक ऑफ कॉन्ट्रैक्ट्स एंड company law. Both of the topics are having a good weightage from exam point of view. So do watch this video till the end for a good practice of questions. Also, this video, these question solvings will help you understand what are the important topics of these subjects and also which are the questionable areas, along with a good revision for you all. The very first question for discussion is, books of account of every company that is relating to a period of dash is immediately preceding a financial year, together with the vouchers that are relevant to any entry in such books of account, shall be kept in good order for not less than 7 financial years, not less than 8 financial years, not less than 15 financial years, till its dissolution, none of the above. And the correct answer will be B, that is not less than 8 financial year. ये क्वेश्चन भी एक्चुअली डायरेक्टली पिकअप किया गया है. बुक्स ऑफ अकाउंट को एक्चुअली आपको कितने सालों तक फाइनेंशियल ईयर्स तक मिनिमम you should keep it in good order, that has been discussed in this particular question, and it has been picked from section 128 relating to books of account etc. that is to be kept by the company. The books of account of every company shall be relating to a period of not less than 8 financial years, that is immediately preceding a financial year, or where the company has been in existence for a period less than 8 years, then in respect of all the preceding years that are taken together with the vouchers that are relevant to any entry in such books of accounts shall be kept in a good order. So this clause 5 of section 128 covers this particular part relating to for how many years it should be kept in good order. Covering section, now coming to question number 2. What is the requisite quorum for the meeting of a private company? This is a question directly asked from private company meetings, requisite quorum. You can see the options are actually a bit near as compared to the question. Options are 2 members personally present, 20 members personally present, 22 personally present, 200 personally present, none of the above. And the answer is A. The quorum that is requisite for meeting of a private company is 2 members personally present. Answer is going to be option A, 2 members personally present. Section 103 of Companies Act covers this quorum for meetings. Unless articles of the company provides for a large number, in the case of a private company, 2 members can be personally present and they shall be the quorum for that meeting of the company. Coming to next question of discussion, it is relating to the topic of prospectus. If a prospectus has been issued with the intent to defraud the applicants for the securities of a company or any other person or for any fraudulent purpose, then every person shall be dashed for all or any of the losses or damages that is going to be suffered by the person who has or persons who have subscribed to that prospectus. So who is going to take that responsibility? Options are, those people will be personally responsible for that. They will be personally liable with any limitation on that liability. They will be personally responsible without any limitation of liability. They will be having liability as laid down under section 447. None of the above. So out of this, you can see again the options are a bit confusing. So such kind of questions you have to solve very keenly and with a lot of focus. And the answer is personally responsible without any limitation of a liability. Personally responsible without any limitation of liability will be there. Personal responsibility will be there, and that is provided under section 35, which explains that civil liability for misstatements in case of prospectus, that is covered under clause 3 of section 35, that notwithstanding anything contained in this section where it is proved that a prospectus has been issued with the intent to defraud the applicants for the securities of a company or any other person or for any fraudulent purpose, then every person who is referred to in subsection 1, they shall be responsible personally without any limitation on the liability. Coming to the next question. This is from Contract Act, consensus ad idem. What it actually means? Mutual agreement, meeting of minds to agree upon the same thing in the same sense, all of the above, both A as well as C. The answer is D, all of the above. All of these mentioned above are actually meanings of consensus ad idem, and if you see, actually literally, even if you are not knowing this answer, but you can see the options and you can guess that they mean one and the same thing. So you can actually put a logic in this case and answer such kind of questions also. Even if अगर आपको ये पहले से provision नहीं पता है तो भी आप ये answer कर सकते हैं. Section 13 covers this of the Indian Contract Act, that 2 or more persons are said to be consenting or agreeing upon the same thing in the same sense, then it signifies that there exists a mutual agreement between all the parties to the contract. Question number 5. Preventive relief is granted to the court by injunction, and that can be temporary also or perpetually also, but that is granted at the discretion of the court, that is granted at the supervision of the court, as a mandatory decision of the court, based on the facts of the case by the court, or no such power is resting with the courts. ये statement actually it's like more like a fill in the blank. यहाँ पे आपको types of injunctions भी कभी पूछे जा सकते हैं. Injunction भी यहाँ पे blank हो सकता है, but यहाँ पे आपको क्या पूछा गया है regarding the nature of injunction. It is resting in the discretion of court, supervision of court, it is a mandatory decision of court, and so on. तो इसका correct answer होगा A, as it is a discretionary power of the court. This is very clear, and at the discretion of the court, explanation is provided under section 36 of the Specific Relief Act, which provides that preventive relief, how granted. Preventive reliefs have been devised to deal with situations where the nature of the contract is of such a kind that neither the grant of damages nor the specific performance is unlikely to serve any purpose. Then the court resorts to restrain the property who threatens to breach the contract to the possible extent. Next question है relating to doctrine of privity of contract, another important topic from this subject. Which of the under mentioned is not an exception to the doctrine of privity of contract? Time barred debt, assignment of a contract, contract through an agent, covenant running with the land, acknowledgement or estoppel. इसमें से कौन सा option correct होगा? Which is not an exception. Okay, always be aware of such kind of questions. They look very easy, but हम कई बार जल्दी में ये questions गलत कर देते हैं because we do not understand that it is an exception. ये not को अगर हम skip कर देते हैं तो we just look at exceptions to this doctrine, but which is not an exception पूछा गया है to the doctrine of privity of contract, and the answer will be A, time barred debt. Time barred debt is not an exception to the doctrine of privity of contract. Section 25 talks about agreements without consideration. They are void unless it is in writing, registered, or is a promise to compensate for something done. On the other hand, doctrine of privity is actually a common law, which is a principle that implies that only parties to the contract are allowed to sue each other to enforce for their rights and liabilities, and no stranger is allowed to confer obligations upon any person who is not a party to the contract, even though the contract has been entered into for his benefit. Next question. When two or more persons make a joint promise, then at that time the promisee may, in the absence of express agreement to the contrary, compel what? Compel one or more of such joint promisers to perform the whole of the promise, all such joint promisers to perform the whole of the promise, either of such joint promisers to perform whole of promise. Promisee has a discretion to compel any such joint promisers to perform whole of the promise. None of the parties and all shall be jointly responsible to perform such a promise. This is relating to joint promises, and the promisee may, absence of express agreement, what kind of condition will be there out of these options? The correct answer shall be what? A. A will be the correct answer. One or more of such joint promisers shall perform the whole of the promise. One or more such joint promisers are going to perform whole of the promise, and that is going to be provided under section 43. As per section 43, it is directly provided that they may be compelled to perform the promise, one of the joint promisers, one or more. Next question पे आते हैं. Quantum meruit. Again, quantum meruit means what? ऐसे डायरेक्ट क्वेश्चंस भी आपको कई बार पूछे जा सकते हैं, एंड यू हैव टू सी द ऑप्शंस. अगर आपको नहीं भी पता हो तो कभी कभी आपको ऑप्शंस देख के लॉजिक लगा के आंसर करना होता है, एंड द आंसर इज डी, दैट इज बोथ ए एज वेल एज बी. As much as is earned based on the quasi contract. So this is going to be the correct answer, that is both A and B. Quantum meruit के explanation पे जाते हैं. As much as is earned, it involves cases where a person who gets benefits while the other party gets nothing, or the benefit or the enrichment which one party has received as a result of the other party's actions. So not a contractual right, but it is based on a quasi contract. Question number 8. Which section of Indian Contract Act deals with provisions relating to agreement without consideration is void unless it fulfills certain criteria as laid down under the Contract Act? And the options are section 15, 21, 22, 24, 25. The correct option is E, that is section 25. This is a direct question. ऐसे डायरेक्ट क्वेश्चन सेक्शन बेस्ड भी कभी कभी पूछे जा सकते हैं कुछ इंपॉर्टेंट एरियाज पे, सो आपको उन तरीके के क्वेश्चंस का भी ध्यान देना है एंड बी प्रिपेयर्ड ऑफ. सेक्शन 25 डील्स विद अग्रीमेंट्स विदाउट कंसिडरेशन. दे आर वॉइड unless they are in writing and registered, a promise to compensate for something done, or a promise is to pay a debt that is barred by limitation of law. Question number 9. Law of contract is not related to which of the following maxims? Quid pro quo, consensus ad idem, essentio mentium, ex nudo pacto action non oritur, actus non facitrium nisi mensitria. इन सारे मैक्सिम में से कौन सा मैक्सिम है जो लॉ ऑफ कॉन्ट्रैक्ट से रिलेटेड नहीं है? दिस इज वेरी एक्चुअली इट इज अगेन इन इजी क्वेश्चन. सारे मैक्सिम्स आपने सुने होंगे, एटलीस्ट आपको ये तो ध्यान में आ जाएगा कि ये कौन से सब्जेक्ट से रिलेटेड है. सो लॉ ऑफ कॉन्ट्रैक्ट से रिलेटेड मैक्सिम जो नहीं है वो है ई ऑप्शन. दैट इज अ प्रिंसिपल that is not from contract law. Just a minute. That principle is not from contract law. It is relating to an act that is done shall be making one guilty unless there is a criminal intent. It cannot be making one guilty. To be guilty under crime, this is relating to a principle from criminal law that two elements are considered as necessary: guilty act as well as guilty state of mind. Whereas other maxims are all relating to the subject of law of contract, like quid pro quo. आप लोग ये वीडियो के पीपीटी डिस्क्रिप्शन में जाके आप इस वीडियो के इस प्रीमियर के पीपीटी को भी एक्सेस कर सकते हैं, और ये सारे क्वेश्चंस के एक्सप्लेनेशंस को आप अच्छे से पढ़ सकते हैं आफ्टर दिस प्रीमियर इज डन. एवरी explanation for every maxim has been provided here. You can go through for a good revision of these concepts. ये सारे maxims आपके लिए important भी है. You may note them down somewhere for your studies later on. As per the Specific Relief Act, a contract can be made by a trustee that shall be in breach of trust cannot be specifically enforced. If it is in excess of his powers, then it cannot be specifically enforced. If it is enforced, then the act agreed to be done is in the performance wholly or partly of a trust. All A, B and C are correct. Either A or B and C are correct. Be aware of such kind of combination options always. When there is given and, when there is given और, इस तरीके के क्वेश्चंस का आपको काफी ध्यान रखना चाहिए. अगर ऐसे इजी क्वेश्चंस को ट्विस्ट करके टफ बनाया जाए, always be aware of. And the options, correct option is E, that is A or B can be there along with C. As per Specific Relief Act, a contract can be made by a trustee in breach of trust, then cannot be specifically enforced, or if it is in excess of his powers, it cannot be specifically enforced, and it can be enforced when the act is agreed to be done in the performance wholly or partly of a trust. So this is provided under section 11, cases in which specific performance of contracts that are connected especially with trusts are enforceable, that is provided under this particular section. Next question. Coming back to company law, the auditor who is appointed under section 139 of the Companies Act may be removed from his office before the expiry of his term only by a special resolution of a company. That can be done by taking approval of the central government in that behalf within 90 days. That can be after obtaining previous approval of the central government in that behalf in the prescribed manner. That can be before obtaining previous approval of central government in that behalf in prescribed manner. After obtaining previous approval of Sebi in that behalf in prescribed manner. None of the above. So the correct option will be A, by taking approval of the central government in that behalf within 90 days. This is actually a direct question from section 139 that has been picked from Companies Act. What is the procedure for removal of an auditor specifically from his office? That can be by a special resolution of the company, जो हो सकता है by taking approval of central government in that behalf, and that has to be within 90 days. Such procedural questions you have to be aware of is asked from Companies Act. Section 140 talks about removal, resignation of auditor and giving a special notice. As per Companies Act, the securities premium account cannot be used for. It cannot be used for which of the following options? These are the 5 options. Securities premium account को आप किस चीज के लिए यूज नहीं कर सकते out of these options? And the answer is payment of dividend. You cannot use the securities premium account for payment of dividend. Section 52 provides for this, that any application of premiums which is received on issue of shares, that notwithstanding anything contained in subsection 1, the securities premium account may be applied by the company for all these situations. ये आप अच्छे से provision पढ़िए, इसमें directly ये answer दिया गया है that it cannot be used for payment of dividends. Next question. Which statement is correct and is relating to debentures that are issued by a company? Debentures are carrying voting right that can be issued. Debentures are carrying an option to convert such debentures into shares that can be issued. Secured debentures may be issued by a company subjected to such terms and conditions as may be prescribed. All of the above, both B and C. So, which of the following statement is correct and is relating to debentures that are issued by a company? The correct option will be E, that is both B as well as C. Debentures carrying an option to convert such debentures into shares can actually be issued, and secured debentures may be issued by a company which is subjected to such terms and conditions as may be prescribed. Section 71 discusses debentures in brief and covers all these provisions. Debentures is a very important topic from company law, and you have to be thoroughly prepared with that. Coming to question number 14. All shares in respect of which a dividend has not been paid or claimed for 7 consecutive years or more shall be transferred by the company to unclaimed dividend account, to investor education and protection fund, to investors, education and portfolio fund, either of the above as may be prescribed, none of the above. तो इनमें से कौन से dividend shares हैं which cannot, in respect of which a dividend has not been paid or claimed, and that is for 7 consecutive years or more, that shall be transferred by the company. So in options में से which is the correct option? The option is B, that is to Investor Education and Protection Fund. Investor Education and Protection Fund, explanation is provided under section 124 of the Act, unpaid dividend accounts, clause 6. All shares that are in respect of which a dividend has not been paid or claimed for 7 consecutive years or more, then it shall be transferred by the company in the name of a Investor Education and Protection Fund, along with a statement containing all the details as may be prescribed. Question number 15 now. 5 more questions left for our discussion today. Which of the following is incorrect with respect to an information that is required to be incorporated in the Memorandum of Association of a company? MOA of a company, AOA of a company, ये सारे topics भी बहुत ज़्यादा important है company law में से. सारे important topics हम लोगों ने इस question series में pick किए हैं. This is going to be very beneficial exercise for you all. Mark all these topics. Name of the company, liability members of the company, object of which the company is proposed to be incorporated, rules and regulations governing the internal management of the company, none of the above. So which of the following is incorrect with relating to information that is required to be incorporated in an MOA? Answer is D. Rules and regulations governing the internal management of the company is never provided under MOA, that is Memorandum of Association of a Company. उसकी कभी ज़रूरत नहीं होती है. The option section 4 deals with the memorandum, and what actually a memorandum shall include is expressly provided under this section. You can go into the details of this section. As per section 408 of Companies Act, the National Company Law Tribunal shall consist of what? NCLAT shall consist of a president, judicial technical members, judicial and technical members, both A and B. और है या and है, ये भी छोटे छोटे words हैं लेकिन इनसे meaning change हो जाता है. Both A and B, A and C, both A and B, A or C. Actually the option should be A and B, A or C. That shall be the correct option. And the answer here will be E, that is section 408 of Constitution of National Company Law Tribunal directly provides that the central government shall by a notification constitute with effect from such date as may be specified a tribunal. Entire constitution of this tribunal is provided here, National Company Law Tribunal, which shall consist of president and such other number of judicial and technical members as the central government may deem necessary to be appointed by notification. So the answer that is correct is actually both A as well as C. Both the clauses taken together will be the correct answer. Coming to the next question, what is Abridged Prospectus? What is the meaning of this concept, Abridged Prospectus? Options are summary of prospectus, which enables an issuer to make a series of issues, memorandum containing salient features of a prospectus, both A and C, all the options from A to C taken together shall be an abridged prospectus, and the answer shall be A and C only. It is a summary of prospectus, and it is actually a memorandum which contains salient features of the entire prospectus. It is not going to consist of option B. ये भी एक डायरेक्ट क्वेश्चन है जो डायरेक्टली सेक्शन 2 क्लॉज 1 में डिफाइन किया गया है अब्रिज्ड प्रोस्पेक्टस का मीनिंग, और वहां से उठाया गया है. क्वेश्चन नंबर 18, व्हाट आर द एक्सेप्शंस टू द प्रोहिबिशन ऑन द इश्यू ऑफ शेयर्स एट अ डिस्काउंट? स्वेट इक्विटी शेयर्स, shares issued to the creditors in pursuance of debt restructuring scheme, shares issued to the creditors in pursuance of any statutory resolution plan, all of the above, both A and either B or C. You can see the questions have been twisted in such a manner कि आपको options को combination में दिया गया है, A and a choice between B or C. So like this you have to be very careful with the options and then only answer the question. This is what is required in the examination. And what are the exceptions to the prohibition on issue of shares at a discount has been asked actually in this question. And the answer is E, that is both A and a choice between B or C. One situation is possible. Section 53 provides for this prohibition on the issue of shares at a discount. Notwithstanding anything contained in subsections 1 and 2, a company may issue shares at a discount to its creditors when its debt is converted into shares in pursuance of any statutory resolution plan or a debt restructuring scheme in accordance with any guidelines that are provided or directions or regulations that are specified by the Reserve Bank of India with its regulations. Which section of the Companies Act deals with the provisions relating to formation of a company for any lawful purpose by 7 or more persons or 2 or more persons, etc. कौन से सेक्शन में ये डायरेक्टली डिस्कस किया गया है? कई बार सेक्शंस पूछे जाते हैं अगर वो इम्पोर्टेंट हो तो, स्पेशली कंपनी लॉ का सब्जेक्ट बहुत इंपॉर्टेंट है. सो आपको सेक्शंस भी कहीं कहीं पता होने जरूरी है. And the correct option here is D, that is section 3. Section 3 clause 1 directly deals with the formation of a company that can be for any lawful purpose by 7 or more persons or 2 or more persons. Formation of a company, section 3 clause 1. Last question for today's discussion relating to schedule. Schedule 7 of the Companies Act lays down provisions relating to what? It lays down provisions relating to infrastructure projects, memorandum and articles, corporate social responsibility, code for independent directors, balance sheet and statement of profit and loss. The correct option is corporate social responsibility. CSR concept is also a good important concept. पता होनी चाहिए आप लोगों को CSR from company law. It is a good and a questionable area. ये जितने भी शेड्यूल्स हैं कंपनीज एक्ट के वो किन किन टॉपिक्स से डील करते हैं ये आपको पता होना चाहिए. सेक्शन 135 clause 3 provides for corporate social responsibility committee also, and it shall formulate and recommend to the board all of that the corporate social responsibility policy will be indicated the activities that are to be undertaken by the company as specified in schedule 7 in areas or specified subjects as per schedule 7 it will be undertaken. Now we are done with part 2 of this video series. We are done with 40 questions overall out of the 100 questions, 60 more left, which I will be covering in 3 consecutive parts of this video series. Also, there is a good news for you. We are conducting a pre-board session for Sebi Grade A Phase 1 2022. That is going to be held on 13th of Feb from 10 a.m. to 11:59 p.m. exclusively at ixamBee. So, for more details, you can visit our website also, or you can also call on the numbers which I am going to make visible again. And Sebi Grade A legal online course is available at ixamBee with all these features exclusively available at ixamBee for legal preparation. And also we have expert faculty for legal. You can come to us anytime for any doubts and queries and requests.